I want to come back to Ms. Rajakumar, who, again, embodies the issue, one of the many challenges of our immigration system before us. I asked you previously what it would mean if the America's Children Act were to pass, but I want to go retrospective a little bit. How would your life have been different over the last few years if you had been able to get a green card already? And as you answer that, you can share with us also can you describe what would happen in your life and with your family if you had to leave the United States?
Thank you for your question. I think that permanent residency would have benefited me in many ways at several points in my life, but specifically over the past few years, especially once I turned 18, it would have given me the independence that I so badly desired. For example, I really wanted to be able to work when I was in college. The out-of-state tuition, as I mentioned in my testimony, children like me don't qualify for any university or federal financial aid. So the $70,000 of out-of-state tuition that my mom took upon herself was an exorbitant burden on my family. She jeopardized our only home, and my inability to support myself due to my inability to work was just an extra stress on the family. Not even being able to take care of my personal expenses. And then in addition, in 2019, if I had my permanent residency, I would have loved to have been able to take off a semester or even a year off school after my brother's passing and really mourn and process and heal and be there for my mother, and had the confidence that I could have picked up my education once again when I felt ready without any impact on my future. If I had to leave first and foremost after being separated from my mother, it means returning to a country that I've only ever been to twice before, a place where I have no place to live, no means of transportation, let alone a license, a career, or a support system, because apart from my mother, even my most immediate extended family reside in the US. So it would quite literally mean starting over completely from scratch. And my only other option of staying here would be to apply for an H-1B application, which would only further my work visa sponsorship and give me a couple more years, but at the end of which I will once again face self-deportation. And the problem again with like these applications is they're fully luck-based, they're pure lottery, does not take into the account that the years that I have spent growing up here. And even if I were to be lucky enough to get an H-1B application and then be sponsored for my green card through my employer as my mom did over a decade ago, I would once again fall towards the back of the line that she was in and the line that I aged out of. So neither option is very viable in my opinion.
And very real circumstances. I want to focus back on the employment-based immigration system for another moment. The number discussed as the numerical limit for employment-based green cards is 140,000. We've referenced that figure earlier in the hearing. But that number does not actually represent the number of people who petitioned for an employment-based green card. Spouses and children of immigrants who accompany an employment-based immigrant actually count against the 140,000 cap. I mentioned that in my opening statement. So therefore, less than half of the 140,000 employment green cards actually go to immigrants selected for employment reasons. A question for both Mr. Legomsky and Mr. Melvin. Can you discuss how exempting spouses and children from the cap would improve our immigration system?
It would have the same kind of beneficial effect with slightly different numbers as some of the other bases for increasing the total cap, such as increasing the base number, recapturing unused visas, eliminating the deduction for immediate relatives, and so on. I see a proposal to exempt the dependents from the cap as being in that same vein, and I think they would all have the same benefits. They would greatly shorten the waiting times for people who, after all, are going to be admitted at some point anyway. It's just that this would allow them to be admitted sooner rather than later, thereby helping the employers who need their essential labor right now, rather than forcing them to wait in the future.
Mr. Melvin?
I agree with Professor Legomsky. I don't have anything else to add other than you can see the snowball effect that when you have a 10-year backlog for a green card, people will marry, they will have children. Those folks are then being added to the line. So a little bit of an explanation of why that backlog is increasing even while doing nothing, just by nature of families growing.
I think it speaks both to the backlog and trying to address the backlog, and at the same time, the purpose for which this was intended to impact employment and the economy. And when a majority of the numbers are not the sponsored entity, but spouses and children of, that's limiting the employment and economic contribution side. So it makes sense to me. Senator Cornyn.